The big news in real estate this week is that the new versions of the REIQ contracts have been released. Yesterday, the 20th of January, the house contract, the 17th edition, and the unit or community title scheme contract, the 13th edition, have been released. Hi to all the agents and everyone watching. My name is Josh Fox, and I'm going to walk you through some of the key changes to the REIQ contracts. The right to extend the settlement date. This change is probably the most significant change. In Queensland, we've always had time of the essence, which we still do, which means that dates are very important. If you don't meet dates and deadlines, bad things can happen, like contract terminations. However, what's now been introduced is a unilateral right to extend the settlement date. Importantly, this is not an ability to extend any of the other key dates, like finance or building and pest, only the settlement date. Both parties have this unilateral, one-sided right to extend by up to 5 days. Each party can actually extend multiple times, but the total extension can only be up to 5 days. For example, they might extend by 2 days the first time and 3 days the second time, and that would be okay. If they extended by 3 days and tried to extend by a further 3 days, that would be too much. Critically, the notice must be given before 4 p.m. on the settlement day, and typically solicitors will be giving these notices. Parties are still free to agree to other arrangements, so there's nothing to stop an extension of a longer time, provided that's mutually agreed by the parties. Also, no default interest will be payable on these extensions because it's an extension of the settlement date, meaning that neither party is in breach for failing to settle on the original or the scheduled settlement date. The change in the contract relating to swimming pools represents a real simplification of the swimming pool certificate provisions. Instead of there being a process of a swimming pool inspection, it really boils down to two key options. Either the seller gives the buyer a notice of no pool safety certificate prior to entry into the contract, in which case it's up to the buyer to obtain a certificate post-settlement, or alternatively, the seller must provide a compliant pool safety certificate prior to settlement. If a compliant pool safety certificate is not provided prior to settlement, then the buyer will be able to terminate. Smoke alarms. As many of you will know, as at the 1st of January this year, new smoke alarm legislation came into place, essentially meaning that smoke alarms now needed to be interconnected to be able to talk to each other, and also that they needed to be hardwired to power or to have 10-year batteries. There is now a clear obligation on a seller to ensure that compliant smoke alarms are in place prior to settlement. If the seller fails to have these in place, the buyer will be able to insist on a financial adjustment of 0.15% of the purchase price. So this essentially equates to $150 per 100,000 of the purchase price. So 4 times $150, so a $600 less financial adjustment on settlement day where the seller has failed to have compliant smoke alarms in place by settlement. To obtain this financial adjustment, it must be claimed prior to settlement, and this is the buyer's only remedy. The buyer cannot terminate for the lack of compliant smoke alarms. Further, the contract now provides for an additional inspection to inspect the smoke alarms, over and above, for example, a pre-settlement inspection. Deposit paid electronically. The provisions relating to payments of deposits, whether an initial or a balance deposit, have been updated. Increasingly, payments are being made electronically or by EFT. These electronic payments are often not instantaneous, and so the contract now tries to provide a deeming provision for when monies are deemed received. Essentially, there is now a 2 business day grace period for the money to land, provided that a buyer has provided written evidence of the fact that they've made the payment and that they have not taken any action to defer or delay the payment. Right to terminate for services infrastructure. There is an express right to terminate if services infrastructure passes through the land which does not service the land and which has not been disclosed by way of a disclosed encumbrance on the contract. This change appears to seek to clarify the position regarding the seeking of damages or termination for undisclosed encumbrances. Where the undisclosed encumbrance does not service the land, there will be a right of termination. However, where the undisclosed encumbrance does service the land, it remains to be seen whether in some cases there may still be an ability to terminate. This will likely depend on whether the undisclosed encumbrance is considered a material defect in title. This can be a complex topic, and so it's always best to refer the clients to their solicitor if this situation arises. Seller's warranties. Under the previous version of the REIQ contract, if a notice requiring works was received after the contract date, this was the buyer's problem. This was considered by many to be an unfair result, and so the new contract seeks to address this. Under the new contract, there's been a change to the seller's warranties or promises as at the contract date and at the settlement date, including a promise that the seller has not received any correspondence which may lead to a show cause or enforcement notice under the Building Act or Planning Act. Required works. There has also been a change as to who is required to do any required works, which depends on the timing of the notice and whether the required works were disclosed to the buyer prior to entry into the contract. A seller does not need to comply with any notice where work is required issued by a competent authority, for example a council, provided they disclose that to the buyer prior to the buyer entering into the contract. Upon settlement, any works required will become the responsibility of the buyer. However, if the required works are not disclosed to the buyer prior to entry into the contract, then the buyer will be able to claim the costs of doing the works as a debt after settlement, or they will be able to terminate where it constitutes a material defect in title. So again, it's subject to that materiality test as to whether you can terminate or not. Contract date and RBA closure. Agents will be aware that the contract has a space for the contract date, which is often handwritten in. But as so many contracts are now being signed electronically, there's now a provision which provides or deems that the contract date is the date that the last party signed. If the contract is signed electronically via DocuSign or similar, that data is captured by DocuSign and we can see when the last party signed. And so that is the deemed contract date. We don't actually need to handwrite that onto the contract under this new addition or these new additions. Also, there is a bit of a rescue provision if the Reserve Bank of Australia offices in Sydney and Melbourne are closed. If that's the case, then that day of closure is deemed not to be a business day, and so if settlement was meant to happen on that day, it would fall on the next business day. Cyber warning. By now, many of you will be aware of the risks of hackers and people trying to divert funds from settlement for fraudulent purposes. So there is now a cyber warning which appears in the contract. This cyber warning appears in the price section of the contract and appears just below where the deposit holder details are inserted. Settlement date rollover. If settlement cannot occur by 4 p.m. on a day and fails, because of the failure of a computer system of the Land Registry, of the Queensland Revenue Office or the Stamp Duty Office, of the Reserve Bank of Australia, of a bank or financial institution, or of an ELNO system like PEXA or Simply or any other new system, then the settlement date will automatically be shifted to the next business day, sort of rescuing the contract in the case of that kind of computer system failure. Contract terms only. It's important to remember that these changes have been made to the contract terms only. For example, these changes talked about will not typically apply to an old version of the contract. There are other document providers other than the REIQ for residential contracts, and law firms will sometimes use customised contracts for the sale of a house or sale of a unit and not the REIQ contract. So it's important not to assume that all of these new changes will automatically apply. The other thing to bear in mind is that typically standard terms in a contract, unless they're things which are embedded in legislation, but for the most part the standard terms of the REIQ contract can be varied by way of special condition. And so it's worthwhile checking in with the clients and talking to the solicitor to see if any particular standard term might not be the best for these particular clients. Solicitors can draft special conditions which undo some of the effect of these changes, or perhaps even expand the intended effect. Thanks for your time in listening. If you have any questions, pop them in the comments below. All the best and good luck out there. Cheers. Fox out.